Hi, thanks for joining me. I hope you enjoyed listening to Joanna Fulton talk about no-fault redress schemes for COVID vaccines last week. Today I'm going to be talking to you about user fault versus product fault and the case that nobody saw coming. Before I begin, I want you to picture a folding camping table. Perhaps the sort of table that looks a little bit like this. What sort of picture does that bring to mind? Perhaps a nice trip to the beach, family barbecue, or even a camping trip. But for me and the solicitor that instructed me on this particular case, seeing these kind of tables brings up far different memories and a very, very particular story. We think about head injuries, product liability insurance, and psychics. Okay, so that's a bit of an odd one. I'll get onto that a bit later. Before I start, my name's Nicola Fallowfield Smith, and I've worked for Hawkins for over 10 years. I'm a chartered mechanical engineer and I've investigated over 500 incidents. Hawkins is a collection of scientists from all different backgrounds, and we investigate whenever things have gone wrong. In terms of product failures, we've investigated cracking mugs all the way up to cracking buildings, and I can safely say that no two cases are ever the same. So, as a solicitor, why would you want a forensic investigator on your case? You're busy people, you're managing multiple cases at the same time, often for demanding clients under very, very tight budgets. Why would you want to spend any of that money on a forensic investigator? Well, we can help to give you the solid scientific interpretation of the technical aspects of your case that allow you to make informed decisions about how to process that case. And hopefully that'll allow you to make decisions about how you're going to continue and then come to some kind of eventual settlement or closure that is both makes both you and, more importantly, your client happy. So you might have used Hawkins before, you might have used forensic experts before, but I've been trying to think about ways that you can get the most out of a forensic expert on your case. First of all, good communication. It's really important that you establish at a very, very early stage exactly what you need. Do you need a full CPR Part 35 court report? Or actually, is your case only at the stage where a simple letter, maybe even an email and a telephone conversation would suffice? You can save yourself a lot of money and time up front if you establish these things at an early stage. Having the original item. So we can do investigations from photographs and videos and other things like that, but it's so much more helpful if we've got the original item. We can look at the failure patterns and the damage to it, and we can establish if that matches what we're expecting to see based on the information that your client is perhaps giving you. Having the correct expert. There's no use having looking at a failure of perhaps a building or a building material and then sending an electrical engineer to do it. I've seen so many cases where problems have come around from people instructing experts who don't really have expertise or any kind of technical knowledge in a specific area. If a case ends up progressing to court, it's always a lot harder for those experts to justify why they're able to call themselves experts in those instances. So make sure you do your research before you instruct anybody and find the best expert for your case. We're always happy to talk to people and point them in the direction of colleagues or even other companies if we think that someone at Hawkins won't be suitable for the job. Make sure you've got all the background information first, and this just saves everybody time. I've had items sent to me where nobody really knows exactly how they failed. Perhaps the item's got evidence of contamination on it, but I can't tell how that contamination has got there because I've no idea where the item was installed or how it was being used. And lastly, make sure you always keep an open mind. Cases like this can often go in unusual directions, and sometimes the information that we give you might not be the information that you were hoping for, or it might not match your client's story. We will always try and give you the most robust scientific advice based on the physical evidence that we're provided with. And if we give you that information and it doesn't match the story that you were expecting, keeping an open mind might help you to take your case in a new direction, or perhaps bring it to an end if you realise that there's no use in proceeding any further with it. So without further ado, I'm going to talk to you about the case that nobody saw coming. Several years ago, I was asked to investigate the case of a collapsed picnic table. A claimant was pursuing my solicitor's client, who was the distributor of these picnic tables in the UK. The claimant had been using the picnic bench when it had collapsed, and they'd fallen back and suffered from a head injury and a fractured wrist. And they were claiming for damages caused by pain, suffering, headaches, and memory loss. The solicitor warned me that the claimant was a bit unusual, and I didn't really know what to expect. So the first thing I did was give her a call, not because I wanted to find out why she was odd, but more importantly, so I could arrange to come round and see the picnic bench. Whilst having a discussion with her, I asked her what she was doing when the picnic bench collapsed, and she told me that she'd been using it for work. Very specifically, she was a clairvoyant who gave psychic readings and did tarot card readings from this table in her house. I arranged to visit the next day, and I really didn't know what to expect. Perhaps a very mystical front room, or maybe she liked to give these psychic readings outside close to nature, and that's why she needed a fold-up picnic table. Turned out to be neither of those things, and in fact it was just that she had a very untidy front room and not much space, and having a fold-out picnic table allowed her to put it out whenever she had a customer. I don't know about you, but there's nothing less mystical to me than a plastic camping table with a reduced sticker still stuck to the top of it, but I suspect I wasn't really her target audience. So these kind of picnic benches comprise of plastic parts that are held together on an aluminium framework, and they're fantastic. The aluminium is incredibly light. It makes the table easy to fold up and move around, which is why it's ideal for camping or trips to the beach and things like that. When I first arrive on scene, it's important for me to establish exactly what the claimant was doing at the time so that I can try and match the damage that I'm seeing to her story. And she told me that she'd been sat on the corner of the table and she'd been getting ready to have a customer visit. She said that she hadn't been getting up ready to move and she hadn't been shuffling around, so she hadn't been moving forwards or back, and that the table suddenly collapsed underneath her weight. She also mentioned to me that since banging her head, she'd actually lost some of her psychic abilities, and as a result, that was affecting her ability to earn. Couldn't help noticing that that particular claim didn't get put in the letter of claim that was sent to the defendant. So having a look at the picnic bench, you can see here that some of the legs are bent inwards. This was the corner that she'd been sitting on. So you can see that it completely kind of buckled and collapsed, and the legs had permanently deformed into this pattern. When looking at these things, particularly this kind of folding structure, it's important to realise that it's very reliant on being erected properly and the weight evenly distributed throughout the table so that all the parts can act as one assembly. This very quickly became a case to me where it was user fault versus product fault. Was there something wrong with the design of the table? Perhaps the materials weren't suitable for the weight, or was there something wrong with the way the user had been using it? Had she not put it up correctly, or had she been using it in a manner that it wasn't intended? So I set about examining the table and looking for evidence of damage. And there was lots to be found. These two pictures show two examples. The bottom one shows a buckled table leg, and the top shows where one of the hinges has started to tear. This kind of damage is entirely consistent with overloading, and it means that the materials just weren't strong enough to be able to deal with the forces that were being put through them. Now, we know that the claimant had been sat on one corner, which means that all her weight was acting in that one area. And it might have been slightly better if someone had been sat opposite her, although of course that would have added to the forces that were being distributed through this table. Now, a case like this, we have to consider weight. Now, I don't know the precise weight of the claimant in this case, and it is something that probably would have had to have come out later if the case had progressed. However, she definitely wasn't one of the slimmest people I'd ever met, and I'd have to go as far to say that she was probably one of the largest. Having looked at this table, it was so clear that it just hadn't been able to, the table hadn't been strong enough to cope with the force. And that led us to think, well, what was the maximum weight that this table should have been able to deal with? So I went away and carried out a structural analysis on the table and found out exactly what the sort of forces we would have been expected to see and sort of the maximum weight that I'd expect. But it's all very well knowing that. What's more important is what it had been designed for. What sort of weight was the manufacturer expecting the table to be able to cope with? In order to establish that, I went to look at the instructions. This sort of product was being imported and it was made in China. And I'd expect to see some kind of maximum weight limit or at least guidance on the instructions. Looking at the instructions, there was no weight limit, which was somewhat disappointing. However, it did have a line that contained this following sentence. The first part read, "suitable for children." This looked like it might work in the defendant's favour because quite clearly the claimant wasn't a child. However, the instructions went on to say, and gentle adults. As a technical expert, it's not my role to get involved in what the legal interpretation of a gentle adult is and whether or not the claimant fell under this category. This is when the case sort of really fell apart. Neither of the sides wanted to argue about exactly what or who a gentle adult was, and it was decided that the case would be settled out of court in favour of the claimant. This is a really good example of a case that started out looking like it was absolutely going to be either a user or a product fault, and it came down to something in the instructions. In my opinion, the table quite clearly was unsuitable for the lady who was using it. It definitely wasn't strong enough to take those kind of weight, especially not concentrated in one corner like it was. And it was always susceptible to fail if she was going to continue to use it. However, of course, because of this one instruction and there not being a weight limit, the case ended up settling in the way that it did. So I kind of want you to go away from today just remembering two things. One, always keep an open mind. And two, if you're dealing with a product failure case, make sure you read the instructions. I really hope you've enjoyed hearing about this today, and please feel free to get in contact with me if you'd like to hear more about this case or any of the others that I've investigated, or you have an inquiry. Next week, you can look forward to a talk from Gemma Pressman, and she's going to be talking to you about product liability in the States and social inflation. Thank you so much and enjoy the rest of your day.